Durable General Power of Attorney. It's an important legal document. Most people have heard of it before, but also most people aren't really sure exactly what it does or why it's an important part of any estate plan. I'm Jason Johnson from Johnson Law here in Annapolis, and we're going to break that down today. So let's start with the name Durable General Power of Attorney. What does durable mean? That's the most common question we get. Okay, so durable just references the fact that the power of attorney will remain, the power itself remains in place even if the principal, who is the person making the power of attorney, becomes incapacitated. So at common law, that wasn't the case. If the principal who made a power of attorney became incapacitated, because they no longer would have the ability to revoke it, it was revoked once you became incapacitated. However, the durable power of attorney survives the incapacity of the principal, meaning that once, if the principal, the person making the power of attorney, becomes incapacitated, that power of attorney, those powers remain in place. And so that's actually really important, because for estate planning purposes, when we're creating a power of attorney, we're doing it because we want it to be effective and for those powers to be in place in the event of our incapacity. So it's very important that the power of attorney, in this context, that the power of attorney be durable. There's also two different kinds of powers of attorney. There are ways to impose the power. There are springing powers and there are non-springing powers. And very simple. It sounds like it might be complicated, but it's not. If you want the power to become effective upon your incapacity, then that's called a springing power of attorney. However, if you want the power to be in place immediately and then survive incapacity, that is a non-springing power. It's durable because it will survive incapacity, but it's non-springing because it's in place immediately. It doesn't rely on one becoming incapacitated. I would say in our practice, durable, non-springing powers of attorney are the most common that we do. Occasionally, after discussing with the client, they want their power of attorney to be springing, and we have a conversation about that. And if the client believes that that's really in their best interest and what they want, after having a full understanding of all of the upsides and downsides, then that's what they do. Now, what does the power of attorney do? It's pretty straightforward. In a power of attorney document, you appoint you if you make the power, you're called the principal, and then you are going to appoint individuals who have power, authority to do things on your behalf. For the general power of attorney, normally these are not healthcare related powers. These are generally more financial type powers, things like banking and being able to buy and sell property, apply for insurance benefits, sue or be sued in the name of the principal, and many, many other things. The powers generally are quite broad, which is intentional. Usually we want the powers to be fairly broad because we can't anticipate what we might need. We might need someone to handle long-term care plan, the financial aspect of long-term care planning on our behalf. We may need to give them really significant powers, like the power to make gifts on our behalf. We also want to include things like the power to apply for government benefits on our behalf. So the powers themselves, generally speaking, should be quite broad. Now, one of the problems we encounter, because a lot of times people, unless they've consulted with an estate planning or elder law attorney, they aren't necessarily, haven't been sort of briefed into the importance of some of those specific powers. And if they do this without receiving proper legal advice, they sometimes have an inclination where they want the powers to be too narrow. They don't want to give their agent sufficient authority, things that would actually be important in real life and in real practice. So that's why we think it's so important. First of all, the power of attorney itself is really actually a very important element to a proper estate plan. I think sometimes people don't quite appreciate its importance, and sometimes for that reason I call it the power of attorney, the Rodney Dangerfield of estate planning, because it just doesn't get any respect, I think. But those of us who practice in estate planning and elder law, we definitely have a lot of respect for this area of planning, making sure that we're ready for prepared for in the event of incapacity, and that we're giving the proper agent sufficient authority to do almost anything that we would be able to do ourselves. We also want to put some safeguards in the event. We don't want to necessarily give our agent powers that we wouldn't want them to do, but it's an individualized determination, something that we have to talk through with our clients about exactly how much authority we want to give to our agents. I think the inclination for most people is not to give enough authority, and sometimes we have to kind of talk that through and what some of the risks of that are. At the end of the day, what we're trying to do is prevent a guardian from ever having to be appointed in the future. A guardian is something that can only be appointed by the court. The process of getting a guardian appointed is time consuming, can be expensive. It adds another layer of complication to families that are really often just trying to do what's best for their incapacitated loved one. And so having a good, thoughtfully drafted power of attorney in place is very important. One more area that I'll just talk about for those who are specifically concerned about long-term care issues is that some of the powers that we would give an agent in a durable financial or durable general power of attorney can be geared very specifically toward that risk that we could become incapacitated and then at some point thereafter or at the same time that we may need long-term care, and we may want our agent to be able to find ways to finance our long-term care that have the least impact on our finances and our family's finances. And in that circumstance, we really need a power of attorney that is drafted in a very particular way. And in that circumstance, you really, really do need to consult a elder law attorney who understands what those issues are, can anticipate the need, and can draft up a power of attorney that contains sufficient authority in that circumstance. Thank you so much for your interest and for listening to this sort of primer on what a durable general power of attorney is and why it's important. If you have any questions or if you want to address your own estate planning concerns, please give us a call at Johnson Law here in Annapolis, Maryland. Thank you.